Hello, welcome to the first session of our Arbitration Boot Camp for 2024. This is the 13th of my series, which I started in 2022. And you can catch up on any of my previous arbitration boot camps, which are recorded and put on YouTube. After this session, you'll actually get a recording and a link to all of the cases that I refer to. So when I refer to a case, you need not scramble to take notes. The purpose of this series, of course, for those of you who are familiar with it, is to provide practical guidance on issues that are common to arbitration that we all hear about. And whether you're counsel or arbitrator, I am hopeful that you'll find these sessions useful. If there's anything that you'd like me to cover in future sessions, please reach out to me. I have to admit that after 13 sessions, I'm running out of topics. So if you've got something fresh that you'd like me to talk about, please do let me know. If you haven't joined me before, the format is that I usually talk for about 45 minutes. I've got the Q&A box open. If you've got any questions, please put them there. I'll also give an opportunity to ask questions at the end. And of course, if you put something in the Q&A box that I don't reach while I'm making my remarks, I will get to those questions at the end. If you are tuning in for the first time and may not know me, I'm a partner at Lerners. I'm an arbitration place arbitrator, and I am also the editor and writer of arbitrationmatters.com, which is a blog that summarizes cases that are released across the country and provides commentary. You can subscribe for free or just check out the website on occasion. I'm constantly updating information and find it quite useful. And I've heard a lot of readers find it useful because of the commentary at the end, which puts the cases in context or simply provides some opinion on the decision or the issues. Today's session, I'll cover, which I call all about arbitration. I'm going to cover what the differences are between court reasons and awards. What does the sufficiency of an award mean? Because there are challenges to awards on occasion on the basis that they are insufficient. What jurisdiction issues can arise in awards? Challenges to an award, dissents, and dealing with contract deadlines that require arbitration award to be delivered within a limited period of time. So first of all, what are the differences between court reasons and arbitration awards? Let's start with the basics. What is an award? It's not defined in the legislation, but it's commonly known that awards finally resolve issues, substantive issues in an arbitration. There can be one award which determines all of the issues on the merits, or there can be multiple awards where more than one determination is made throughout the arbitration, and a partial award, for example, will be issued to determine those issues. So we see these when there are awards on jurisdiction, interim awards, costs awards, so long as they finally determine a substantive issue in the matter on its merits, those will be called awards. The legislation also provides for corrections or amendments to awards after they've been issued. So 30 days after the award has been issued, there's an opportunity for a party to apply for, in Ontario, typo correction, calculation errors, adjustments, and injustices caused by oversight. Usually these issues are raised by the parties. Under the model law, the requirements are slightly different. Calculation correction, clerical errors or typos, and interpretation of the award if both parties agree. An award, as opposed to a procedural order, is also enforceable under the New York Convention, which is the name everybody calls it, but the formal title is the Convention on the Recognition and Enforcement of Foreign Arbitral Awards. And the significance of an award and the fact that it is enforceable under the New York Convention is that it makes enforcement of an award easier than a court order. And the reason for that is that there are about 165 countries at this time which have signed on to the New York Convention, and the process for enforcement of those awards, therefore, is very simple because of the number of signatories. And obviously, the enforcement is easier in the signatory states. An award also must meet certain requirements under the legislation. Those are requirements relate to form. There must be reasons in an award, unless, of course, the parties consent to no reasons. For example, they would just simply like an award that records a settlement agreement that they have reached. And the legislation provides that the award must be signed, dated, and the place of the award indicated. An award is to be distinguished from a procedural order, first of all, because it cannot be enforced under the New York Convention, and it's not appealable. A procedural order may well form the subject of a set-aside application if a party argues that there was an unfairness as a result of that procedural order. So once the award has been issued, a party may later claim that one of the procedural orders is evidence of an unfairness which justifies a set-aside order. And lastly, the difference between an award and an order is, of course, substantive and meaningful. And so the label is not critical. It's what the order or the award does. However, if there is a mislabel, that could obviously relate to disputes between the parties and delays and costs wasted on trying to determine the nature of the order or award. So it is very important to have the label correct. The next issue is sufficiency of reasons in awards. There are parties who will perhaps appeal an award or seek to have it set aside on the basis that the reasons are not sufficient. And I'll review in a moment what that means. But one difference between court reasons and an award is that the case law says that the reasons in an award need not be as detailed as those of a court. And once you hear me go through the law, the case law that refers to that, I think you'll be probably as confused as I am and wonder if the distinction is more theoretical than real. Here's what the case law says. In a case called Shiragi against Devanagai, and again, I've got these cases and their citations and links in the material that you'll get following this webinar. The articulation of standards of a reasoned an award are simply that an award need not meet the standards of a judge's reasons in court. In the Lululemon case against Industrial Color Productions, the court said that parties' expectations as to the completeness of arbitrators' reasons are less than the reasons expected of a judge. In the Wang against Takar case, which contains a really good summary of the principles of what makes an award sufficient, in that court said that award must show the why, even if not the how. In Charlottetown Equities against Charlottetown Airport, there is a really good discussion of the law regarding the sufficiency of an award. And that court says, reasons should have facts, application of facts, and law. And one of the reasons is to provide informed grounds for consideration of grounds for an appeal. And those are reasons in an award. So must be sufficient to allow a court to determine whether an appeal should be granted or not. And under Peralta against Peralta, 2019 Ontario Superior Court Superior Court of Justice judgment, which unfortunately is not reported. It says the length or brevity of the reasons does not equate to sufficiency or insufficiency, which sounds obvious. It is said that the award need not address every argument, but must show that the arbitrator understood the parties' positions and the evidence and show what was accepted and why. So there should be a facts, law, and application of the facts section. In other words, do the parties really understand why the award was made? Why is this distinction between court reasons and the reasons in an award important, or what justifies this distinction? First, an award, because it arises out of a private arbitration, has no precedential value. It doesn't advance the development of the law in any way. So it's really only for the purposes of the parties. So there's a distinction to be made between the public and private purpose of court reasons and reasons in an award. Very few arbitral awards become public, and those only become public when they are reviewed by a court, either by way of appeal or set aside. And the reasons why arbitral awards can be less sufficient, if I can use that word, than court orders, is that there are policy considerations which drive arbitrations, obviously, that don't exist in court proceedings. And those policy considerations relate to the speed and efficiency of arbitration, which means that expecting less detailed reasons advances those policy objectives. And the consequences often are that a court is less likely to interfere with an award on set aside or appeal. And as a little aside, I think that this may well explain the court's approach to the Vavilov decision since it was released in 2019. And I'm sure most of you know about the decision of the Supreme Court of Canada in Vavilov, Minister of Citizenship and Immigration against Vavilov, which is a appeal of a judicial review decision in which the court determined that the standard of appeal was the appeal standards under Huson and Nicholson, another Supreme Court of Canada's decision. But the question that has arisen since the release of that decision is whether that standard of review applies in appeals of commercial arbitration awards. And to fast forward, that issue has been undecided. But the previous Supreme Court of Canada decisions on this issue were Satva and Teal-Cedar, and they determined that an appeal of a commercial arbitration award should be determined on a standard of reasonableness unless there was an inextricable error of law which could be decided on a standard of correctness. And of course, most arbitral awards are not inextricable questions of law because the very issue is usually an interpretation of a contract, which the Supreme Court decided on in Satva was a question of mixed fact and law. The alternative, which Vavilov suggests, is an appeal standard because the arbitral legislation provides for an appeal, in which case the Huson and Nicholson 2002 decision of the Supreme Court of Canada, that test would apply, which is that issues of fact or mixed law of facts would be determined based on a palpable and overriding error, and questions of law would be determined on correctness. So those are quite significant different standards of review. And as I said, there's been no determination about which of the standards will apply in a commercial arbitration award context. But the courts at the moment invariably say, well, I will make the same determination regardless of which standard of appeal applies. So it doesn't really matter. And so to go back where I started when I just started talking about these cases, in my view, this may be an example of the different policy considerations that underlie arbitrations as opposed to court proceedings, and the reluctance of courts generally to interfere in arbitrations. There's no court judgment that says that. I'm just making my own analysis there. So the question is whether this different expectation as to the sufficiency of awards and court proceedings really makes a difference in practice. In other words, is this really a theoretical issue? Does it really matter in practice? And the reason I say this, as there appear to be more challenges to awards than there have been ever before. And why is that? The grounds for intervention may be unclear. And so one of the answers may be that parties, because there are more arbitrations, there are more challenges to the arbitrations. And in some cases, there will simply be parties who are unhappy with the outcome and are seeking to challenge it, either by way of set aside or appeal or both. And so arbitrators, appreciating that there are more such appeals, may be deciding to make their awards more detailed, more like court judgments, in order to address that issue. More arbitrations are also being done by commercial litigation counsel, who may not be specialists in arbitration. And the reason that's significant is they may not have bought into the idea of the finality of domestic arbitration. And the reason I say that is there are many counsel who do largely commercial litigation who are very surprised that the model law does not provide for an appeal. And many of them view that as a significant problem when it comes to justice. So it may be that those counsel are concerned about that issue, and they then pass that concern along to their clients. So the idea, the expectation about what awards should look like may well be informed by their experience in the courts. There may also be an idea that the judge of an arbitrator is just not as good as a judge's decision. And so arbitrators are therefore trying to create awards that look very much like judgments in order to address that concern. We often see applications for leave to appeal and set aside applications on the basis that the reasons are simply not sufficient. The parties or the party doesn't understand what the reasons mean. So what is the solution? Should arbitrators, in light of those concerns and in light of the case law, which is, I say, probably unclear, should arbitrators, in a sense, write defensively and specifically draft an award that would be sufficient in the courts in order to reduce the number of appeals or set-asides, or the concerns that counsel may have that they're getting a second-rate type decision because of these expectations referred to in the case law, that the award need not be as detailed as court reasons, and the lack of clarity with respect to that requirement. And the concern with that, and the problem with that, of course, is that no arbitrator, no matter how detailed the award, can ever avoid a challenge to the award. In other words, there are many creative counsel and determined parties who will challenge the award no matter what. And of course, there are cost consequences which result if the arbitrator is taking more time to draft an award, which the case law says need not be as detailed as a judge's award. And of course, the delay that will result from a more detailed award. This whole issue about sufficiency of the award, of course, raises important policy and practical questions. So one of them is, does a more reasoned award that would look like a court award make it more likely that the answer will be right because the arbitrator has thought about it more? And so should parties want to have that level of detail in their awards? Does an award that is more likely, that is more detailed, make it more or less likely that there will be a court challenge? Is there a different standard where there may be an appeal or a set aside only? In other words, should the arbitrator write the award on the basis of knowing whether or not an appeal is possible and whether the only possible remedy is a set aside application? There are cases where parties will specifically seek summary reasons to save costs or to expedite the process. And if you're counsel, you may consider whether that's a decision that the parties may later regret, because it may impede the ability of a party to seek appeal because the reasons don't provide specific foundation for a court to understand the reasons sufficiently in order to determine whether there has been an error of law or an error of mixed fact and law, depending upon what the legislation or the parties' arbitration agreement provides. And an important consideration is the parties requesting reduced or less detailed reasons are not agreeing to insufficient reasons. And so parties agreeing to shorter reasons may still be able to obtain an award or a set aside of the award on the basis that the reasons are not sufficient. So you can see the conundrum that parties face and arbitrators face. So for example, the Nolan and Ramirez case, a 2020 decision of the BC Court of Appeal, said that the appeal could not be determined because the parties chose less detailed reasons and the court couldn't understand them. The court also made the comment that requiring only summary reasons was penny wise, pound foolish. Nolan and Ramirez, another decision, was that the parties again agreed to summary reasons as opposed to full reasons. But those reasons, the court said, must provide more than just a conclusion. So the reasons must still demonstrate how the determination has been made. And in this case, the parties went back to the arbitrator for more detailed reasons, and the arbitrator agreed to provide more detailed reasons if paid. And a lot of people who do mostly litigation are somewhat surprised by the position of the arbitrator that he or she would do more work if he or she got paid. And in fact, that's not such an unusual situation in arbitrations, where the arbitrator, for example, will not release the award unless until the arbitrator receives sufficient money in order to cover all his or her fees, if, for example, the initial deposits are not sufficient. And another decision called Alvarez and Alvarez of the Alberta Queen's Bench said the awards were abbreviated because they wanted to save time and costs, but again, they could receive additional reasons if they paid additional costs. So I've now summarized essentially what the case law says about sufficiency of reasons and the policy and practical reasons why parties may choose one or the other and the difficulties that arbitrators face. And I don't have an answer for you about what an award should look like in light of all of those considerations, notwithstanding the clear case law that says an arbitrator's award need not be as detailed as court reasons. The next issue I'm going to raise is jurisdiction issues that can arise in awards. Under the model law and the provincial domestic legislation, there is provision for set aside of an award based upon the parties' fundamental rights to be treated fairly and equally and to have a full opportunity to present their case. Jurisdiction issues can arise where the arbitrator either deals with issues that were not put before them, which means the arbitrator steps outside the jurisdiction that is provided to them by the parties' agreement. And what that means invariably is that the arbitrator will decide an issue which the parties have not had an opportunity to address, and this provides grounds for set aside. So it's very dangerous for an arbitrator to go beyond submissions made by the parties. And this can arise frequently where the arbitrator thinks something is missing from the analysis, and looking at all of the material that's been provided, thinks that issue is important to the award. And the best practice is for arbitrators to go back to the parties before the hearing closes and ask for additional submissions on that one issue. However, if the hearing is closed and the arbitrator is in the process of drafting that award, there's no opportunity to do that, and the arbitrator must simply deal with the evidence and the argument that's before them, or risk a jurisdictional argument that may result in a set aside of the award. The other way in which an award may fall afoul of jurisdiction issues is that the arbitrator does not deal with all of the issues that's been put before them by the parties. And so what we see sometimes in the case law is the grounds for set aside are that the appeal procedure was not as agreed by the parties. And the issues should be reflected and the process should be reflected in the procedural orders procedural history of the award. So what that means is the arbitrator must be alive to both the issues that were raised and the issues that were not raised. And if that will found the basis of perhaps an argument as to the sufficiency of the award. There is no separate ground to set aside an arbitration award on the basis of sufficiency. And likewise, if there's an issue with the award, that it may give rise to an appeal, but the sufficiency of the award alone is not sufficient to found an appeal. I've got a question here which says, assuming sufficient reasons, would an appeal of a unanimous 3-member panel award be less likely to succeed than a single member panel? Are 3 minds more convincing than one? I don't think we can predict whether an appeal is more likely to be successful, but you raise a question that parties consider when they decide whether they want 1 arbitrator or 3 to decide an issue. Of course, there are cost consequences for parties choosing one or the other, but psychologically, you hear that counsel and parties will say, well, the decision is more likely to be correct because we've got 3 minds as opposed to 1 addressing the issue. So I think it's more of a psychological issue in the appointment process. And it may well be correct that 3 minds are more likely to reach the right conclusion, assuming they're unanimous, of course. But that doesn't affect how likely it is that an appeal will be successful. The next issue is challenges to an award, and I've talked about those a little already. The challenge must be characterized, even if it's a sufficiency challenge, as an error of law on an appeal. So, for example, the reasons prevent or the award prevents a meaningful review, or there's an unfair process, like the party wasn't heard. But these are remedies that have specific requirements. And we often see argument that parties who are advancing both a set aside or an appeal ground are faced with an argument that they have improperly joined the two, and that really what's before the court is a disguised appeal. And so you often see in the case law that one of the first things the court has to address is this a proper set-aside application? Is this a proper appeal? If not, what is the nature of the proceeding? There are a couple of recent cases that I think are of note. The Wang and Takar case says inadequate reasons may be an error of law reviewable on an appeal. The Escape 101 Ventures and March of Dimes case is one that many of you have heard about. It's a decision out of the BC Court of Appeal in 2022. And it stands for what I say is the novel proposition that an error of fact going directly to the outcome of a case is an error of law. And the BC Court of Appeal is uniquely of that view at this point in time. I haven't seen that issue addressed in that way in the other provinces. However, the leave to the Supreme Court of Canada was denied in that case. And of course, that reason for that is very significant because it opens up the grounds of potential appeal, which if the arbitration agreement or the legislation provides is available only on a question of law, under this case, potentially allows questions of fact to be reviewable on appeal. The set-aside application, interesting case called Alberta Cricket Association against Alberta Cricket Council, that says that a set-aside application may be successful where the award is insufficient because of Section 38 of, for example, the Ontario Act that provides that the award must contain reasons, and if the reasons are insufficient, it may be found that there is a failure to follow a procedure in the Act, giving rise to set aside. So you can see how creative some of the reasons are for advancing or allowing a set aside application. But again, sufficiency is not a ground. Under the Ontario Act, this is addressed as a party not being treated fairly or unable to present its case, which of course is a set aside ground. And similarly, under the model law, the ground is the procedure was not in accordance with the parties, where the arbitration requires the application of the model law or certain rules which require a reasoned award. So the next question that can arise is whether it's necessary for a party to seek clarification of the award before challenging the award on the basis that it's insufficient. And as I've said a few minutes ago, the domestic award, the domestic act and the model law give parties 30 days to ask for clarification, essentially, of the award on certain grounds. So is a party required to go back to the arbitrator to, quote, fix the award before challenging it later on before the courts? And the current case law is that this is not necessary. I find that surprising, but that's where we are. The question is, of course, that I think naturally arises is that failure to seek correction or explanation, if it's available from the arbitrator, could constitute a waiver of the right to complain. Or alternatively, does the party have a substantive right to an award that meets the standard? Those are the two opposing arguments. But at the moment, the courts find that without having gone back to the arbitrator, assuming there's a right to do so, the party is not prohibited from later challenging the award as an appeal or a set-aside application. The next issue, which I think is a really interesting one, is dissents, which you see very rarely in awards, but you do see them occasionally, and some of them become quite high profile, particularly if they then found the basis for either an appeal or a set-aside order and thereby become public. So let's go back to the requirements under the legislation. An award may be made by a majority on a tribunal. There is no requirement that an award be unanimous. Under Article 29 of the model law, an award may be made by a majority. Under Article 29. Under Article 31, sub 1, the signatures of the majority are sufficient, and this is to make it compliant under the legislation. Under the UNCITRAL rules, there must be an explanation if one of the arbitrators doesn't sign. On the other hand, under the Ontario Act, Section 38, sub 3, an award must be dated and signed by all the members of the tribunal, or there is an explanation why one of the arbitrators has not signed the award. So the policy reason for that is it must be clear that all of the arbitrators had an opportunity to participate in the process and in the deliberations. A dissenter may even sign the award, so long as the dissenter, it's indicated on the award that one of the arbitrators dissents. A dissent need not be part of the award, and it is not actually part of the definition of award. So a dissent may be actually issued later. And what that means then is that the deadlines for seeking clarification, for appeal, for set aside start to run when the award of the majority has been issued, and not necessarily when it need not wait for the dissent to be issued. And so what's really desirable is for the dissent to be issued at the same time as the award, even though it doesn't form part of the award. So it raises the question, Is it better to have a unanimous award? Are there downsides to a dissent? Why would a party ever want a dissent, and why would an arbitrator ever want to issue a dissent? So some of the practical questions. Does a unanimous award make it less likely that there will be a challenge to the award? A dissent probably will give rise to an appeal or a set-aside application. That's just reality, because another arbitrator viewed the case differently. Are the parties more satisfied with the outcome if there is a unanimous award? Again, 3 people agree, or 3 people agree. Is it more likely that the award is correct, and it's less likely to be overturned on an appeal or a set-aside? So this is related, of course, to the question that I just answered that came up on the Q&A box. Does a dissent undermine the confidence of the parties in the process? Because there may be no options for the unhappy party if there's no appeal. There may be only a set-aside option, and if the concern is not fairness, the party may have no recourse to an appeal if the dissent raises issues that cause the party to question the decision of the majority. There's no value to the award or to the dissent in the sense of a stare decisis purpose. So it really only affects the parties. So why dissent? There may be reasons where an arbitrator feels duty-bound to dissent. For example, if the arbitrator finds that the process has been unfair, the arbitrator presumably finds this significant enough and affects the rights of the parties so much that the arbitrator issues a defense. And there are alternatives, though, which the arbitrator should consider. Should the arbitrator resign? Perhaps the arbitrator feels that the deliberative process has been unfair, but the process of the arbitration has not been unfair. And that's tricky because of the concept of deliberative secrecy. There are some high-profile cases that have become public where an arbitrator has dissented on the basis that either the process or the deliberative process was unfair, that a fellow arbitrator was biased, that sort of thing. And you can imagine how difficult that is for parties when the avenues that they may have to remedy that are so limited, and how strongly the arbitrator must feel about these issues in order to take these steps and realizing the consequences, not just to the fellow arbitrators' reputations and perhaps that arbitrator's reputations, but also to the parties in the way of delay, costs, uncertainty in the fairness of the process, all of those things. So it's the arbitrator who dissents probably does so with quite a heavy heart. One of the other questions that emerges is whether the arbitrators in their deliberations can reach a conclusion in which, at the very least, there's a concurring opinion or award as opposed to a full dissent. And so this raises the issue, of course, of what goes on in the deliberations among the various members of the tribunal. There is a clear obligation of the chair to ensure that the tribunal functions effectively. So this is why it is so critical that the appointment of a chair be given serious consideration. And that is whether the parties choose the chair themselves or whether they have input into the choice of a chair through their party appointees. But the personality, not just the experience of the arbitrator, becomes very important when you consider this issue, because you want a chair to have the kind of personality that will allow for relationship building, possibly the mediation of disputes, leadership, ego stroking is not the word I want to say, but the ability to work through clashes of ego and strong personalities and that sort of thing. Because it may be that is the difference between perhaps a unanimous award and a dissent, but at the very least, concurring award and dissent. The most important thing is to ensure that the principle of independence and impartiality of the arbitrators is intact. And that's another reason why choosing a chair carefully is important, to ensure that none of the arbitrators feel that they're somehow compromised or not heard. The integrity of the arbitrators and of the deliberation process is absolutely critical. And the dissenting party may form an important part in making sure that all of the arguments are heard. But if the dissenting arbitrator becomes disruptive and fails to participate constructively in the deliberative process, that's a very tricky issue to deal with because, of course, of the concept of deliberative secrecy. And so I've heard of arbitrators who deal with that by contacting the institution, for example, for help on how to deal with the arbitrator. One of the challenges is that the chair can't actually speak to the disruptive arbitrator alone. All of the discussions about the arbitration need to take place in the presence of all three arbitrators, which, as you can imagine, can limit the way these kinds of things can be dealt with. It may be on occasion that one or more of the arbitrators feels the obligation to resign, even at the stage of the deliberations, which would be extremely unfortunate. And the amount of information that the parties are entitled to receive is, of course, very limited. So I go back to the importance of the chair and even the importance of the arbitrators that the parties choose. This is a rarely raised issue, but you can imagine that when it does arise, it can be extremely difficult to manage. One of some of the other challenges to consider when you're looking at the issues of dissent relate to whether the chair has a deciding vote, because that has implications on what the award looks like. What if the chair is the dissenter? What happens to the award? What is the line to be drawn about whether a dissent is necessary or not? And you may have heard that there are some statistics in the international context which report that most dissents favor the position of the party who appointed them. And that has led to a conclusion on the part of some researchers that this concept of independence and impartiality is really not followed in practice and is really more theoretical. And that it's human nature that a party appointee will favor the side that appointed him or her. And I think there are a number of other explanations for that. And so the suggestion that there should be processes in which the parties have the arbitrators have no insight into which party appointed them are probably not necessary. And one of the explanations that does make sense is that parties who appoint a tribunal in an international arbitration, who appoint a member of a tribunal, may appoint somebody who has an understanding of their language, of their culture, of their legal tradition, which may make it more likely that their party appointee will understand their case and favor their case better. And so I think there are some concerns about independence and impartiality, but no real explanation. And that explanation, I think, makes sense to me. As I said, there's no timeline for the issuance of the dissent in the legislation, should there be, because of the potential implications for a challenge. What is the use of a dissent if it's delivered too late? And there's no way that this can be enforced. Most terms of appointment contain terms that the arbitrator cannot be called as a witness. So if unfair process is an issue instead of a problem with the reasons in the award that can be reviewed on appeal, how does a party ever really get to the bottom of why there was a dissent? And so there is a perceived unfairness with the deliberative secrecy process. Overall, there are good reasons, good public policy reasons for that privacy to exist, but you can imagine in any one case, a party may feel disadvantaged by that rule or feel that it is unfair. And there's a possibility that the dissent could create enforcement challenges in certain jurisdictions. So what do arbitrators do in the deliberation room when there is a risk of a dissent? And I think the best answer is that they are duty bound to do their best to come up with an award that meets with the approval of every arbitrator, but they're not required to do so, and they must follow their own thinking and maintain their independence and impartiality. So how does all of this fit within the earlier discussion about sufficiency of reasons? Is it necessary for a majority award to provide more detailed reasons in order to address the reasons in dissent? Certainly the dissent may improve the majority reasons by addressing certain issues that the majority may have not thought about, or where there's simply a disagreement. So the best practice, of course, is to have the arbitrators exchange their awards, which will probably improve both of them. But how does that address sufficiency of reasons? And presumably both sides will beef up their analysis in order to address the reasons of the other arbitrators. The last issue, and the one that's probably the easiest, is dealing with contract deadlines for the delivery of the award. And where this usually comes up is when an arbitrator is contacted to be appointed and gets the arbitration agreement, which is absolutely critical, and sees that there is a deadline within the arbitration agreement that requires the award to be delivered within, let's say, 30 days of the date of appointment. And the arbitrator appointment candidate views that as completely unrealistic. What do you do? Again, it must be addressed before appointment. Once the arbitrator has accepted the appointment with that deadline, the arbitrator must meet it, or there are significant consequences, which I'll review in a moment. If the arbitrator doesn't have time to do the award within that time period, the arbitrator must not take on the mandate without making that very clear and ensuring that the deadline is changed. Parties can change a deadline that they've included in their arbitration agreement. Of course, an arbitration agreement is a contract, and if the parties agree to change the date, that's enforceable and should be recorded in a procedural order and referred to in the procedural history of the final award. But some questions arise. Is the deadline a reasonable one? Is it one that is necessary because of a certain issue that's arisen in the party's contract? So it may be that this is not just a unilateral, arbitrary deadline. There may be good reasons for it, which, if the arbitrator raises, can be discussed among the parties, and they may decide that there is no issue because they really would like that arbitrator. And as we know from some of our recent sessions, sometimes choosing an arbitrator is a lengthy process for the parties, and it's fraught with disagreement. And if they finally reached agreement on an arbitrator that they are prepared to move forward with, that may be difficult for them to find somebody new, they may agree to be flexible about the deadline. But it really is the arbitrator's responsibility not to take something on with a deadline that he or she doesn't believe can be met. Perhaps the arbitrator says, well, I can't do this and meet the deadline using a regular arbitration process under the rules, the standard rules, or without them. But an expedited process may allow for the full arbitration to be heard in sufficient time for the reasons the award to be delivered within the time the parties have agreed. So that makes sense to erase that. Again, should be recorded as an agreement among parties to protect the award. And that may be a creative reason, a creative opportunity that the parties have not thought about. If the parties have not agreed to an extended period of time, and the arbitrator can't actually issue the award within the time frame, there are very serious consequences. Although the court may have jurisdiction to extend the time for delivery of the award, even after the award has been issued, depending upon the seat, this is a matter of jurisdiction, discretion by the court, and an arbitrator may not get that leave, either if the arbitrator seeks that relief or the parties do. So it really isn't a risk worth taking. The consequences are serious, both to the arbitrator's reputation for failing to deliver an award within the time required. Of course, there may be perfectly legitimate reasons like health reasons, which would affect the ability of the arbitrator to deliver reasons on time, and presumably that's something that can get agreed upon by the parties. But the risk is that if the award is delivered late, the arbitrator has lost jurisdiction, and you can be sure that by the time the award is issued, the party which has lost will not be interested in agreeing to an extension of time to allow the arbitrator to have the award issued within the new deadline. And the parties themselves may suffer serious prejudice, both in the delay by having perhaps to retain a new arbitrator, the costs that will have been incurred from the arbitration, which has now made its way all the way to the arbitrator for final award. And of course, the parties would be perfectly justifying in challenging whether the arbitrator should be paid all or part of the fees. And if they're on deposit, the parties will actually have to seek the return of the money that's already been paid to the arbitrator. The other issue that can arise is what happens if the arbitrator resigns in the middle of the arbitration and there's a deadline that the arbitrator is required to meet and has resigned before that occurs. There are, of course, provisions about what happens when an arbitrator has resigned or is unable, in fact or in law, to finalize the award within the time period. So, for example, illness is a good example. The court and the parties don't agree on what happens, or their arbitration agreement doesn't address it. It may be that the arbitration has to start fresh, and you can just imagine how upset parties will be if that occurs. So I guess my advice is that, you know, arbitrators can't obviously predict where there will be issues that arise that make them simply incapable of finalizing the award within the time limit. But the arbitrators simply should not take on a mandate without the confidence that the award can be delivered on time, and should deal with that before the arbitrator is appointed, after which it'll be too late for the parties to insist that the parties agree. So those are all my remarks. It's 12:53. I've got about 7 minutes left. If anybody has any questions, feel free to put them in the Q&A box, and I will wait for a minute or two to see if any of those questions arrive. Okay, I don't see anything that has come into the Q&A box. Thanks very much for joining me. Our next session in February, I just can't remember the date on the top of my mind, will be about the differences and the benefits and the pros and cons of institutional versus ad hoc arbitration. So I hope you'll join me then. Have a great day.